All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte.
Okay, thank you. Good morning, everyone. Court officer, you may call the case.
Thank you, Madam President. Situation in the Republic of Côte d'Ivoire in the case of the prosecutor versus Laurent Gbagbo, ICC 0211-0111.
Thank you very much. May I ask the participants to please introduce themselves for the record, starting with the Office of the Prosecutor.
Good morning, Your Honor. I'm Fabrizio Guariglia, Prosecutions Coordinator in the Office of the Prosecutor, and appearing with me today are Mr. Reinhold Gallmetzer and Mr. Julian Ederfield.
Thank you very much. Now the defense, please.
Good morning, Your Honor. If you would allow me to present Mr Laurent from the Côte d'Ivoire Bar, and you have Jennifer Nauri, legal assistant. Behind me on the left, Professor Jacobs from the University of Leiden, our intern Claire White, and our case manager Barbara Le Guenec, and Anne-Emmanuel Alit, counsel. Thank you.
And now the representatives of victims.
Good morning, Your Honors. Victims in these proceedings are represented by the Office of Public Counsel for Victims. Appearing today, Mr. Dimitro Suprun, counsel, and I am Paulina Massidda, principal counsel.
Thank you very much. This morning, I shall summarize the judgment of the Appeals Chamber on the appeal of Mr. Gbagbo against the third decision of the review of his detention pursuant to Article 63 of the statute, in which the Pre-Trial Chamber 1 decided that Mr. Gbagbo should remain in detention. I should emphasize that the written judgment, which will be filed confidentially and in a public redacted form after this hearing, shall be the authentic version and not this summary. The Appeals Chamber, after careful deliberation, decides by majority, Judge Anita Oschaska dissenting and Judge Eki Kurula appending a separate opinion, that the decision of the Pre-Trial Chamber 1 of 11th July 2013, entitled Third Decision on the Review of Laurent Gbagbo's Detention pursuant to Article 63 of the Rome Statute, is confirmed. I shall now summarize the reasons for the Appeals Chamber's judgment. Mr. Gbagbo's appeal is founded on 10 grounds, which will be discussed in turn. However, preliminary, the Appeals Chamber will address Mr. Gbagbo's overarching arguments regarding the sufficiency of the reasoning of the decision of 13th July 2012, which was the initial ruling on detention pursuant to Article 62 of the statute, as well as the sufficiency of the reasoning of the impugned decision. The Appeals Chamber dismisses these arguments on the basis that the reasoning in of the decision of 13th July 2012 was previously held on appeal to be sufficient. Similarly, the Appeals Chamber finds that Mr. Gbagbo fails to demonstrate an error that would have materially affected the impugned decision in relation to the sufficiency of the reasoning in the impugned decision. Accordingly, these arguments are dismissed. The first ground of appeal. In relation to the first ground of appeal, Mr. Gbagbo submits that the Pre-Trial Chamber erred in law by finding that its recent decision to adjourn the confirmation of charges hearing in order to allow the prosecutor to consider providing further evidence or conduct further investigation with respect to all charges, which I will refer to hereinafter as the adjournment decision, did not constitute a changed circumstance requiring verification that the conditions under Article 58(1)(a) of the statute is still met. Mr. Gbagbo submits that the pre-trial chamber's finding in the adjournment decision that there was a dearth of probative evidence to support the charges against him is a new factor which may affect the existence of reasonable grounds to believe that Mr. Gbagbo committed a crime within the court's jurisdiction, and that it was therefore incumbent on the chamber to verify de novo whether Article 58(1)(a) conditions continue to be met. The appeals chamber recalls that in the adjournment decision, the pre-trial chamber indicated that, and I quote, the prosecutor's evidence, viewed as a whole, although apparently insufficient, does not appear to be so lacking in relevance and probative value that it leaves the chamber with no choice but to decline to confirm the charges, unquote. This indicates that while the prosecutor's evidence in relation to the charges against Mr. Gbagbo was inadequate, there remained a degree of suspicion in relation to his alleged commission of the crimes. Furthermore, the pre-trial chamber specifically adverted to the progressively higher thresholds applicable in the course of the different stages of the proceedings, including the fact that the evidentiary threshold for the confirmation of charges is higher than that required to issue a warrant of arrest. In the impugned decision, the pre-trial chamber reiterated this by stating that the findings under Article 58(1)(a) of the statute, and I quote, are made to a significantly lower standard of proof, unquote, than those under Article 67(1). And the fact that the available evidence did not meet the evidentiary threshold for Article 67(1) does not mean that there was insufficient evidence for the purposes of Article 58(1)(a) of the statute. In light of the pre-trial chamber's analysis of the different evidentiary threshold in both the impugned decision and the adjournment decision, and its election to adjourn the confirmation hearing rather than decline to confirm the charges, the appeals chamber thus finds that the pre-trial chamber did advert to the issue of whether the sufficiency of the evidence affected the conditions under Article 58(1)(a). Accordingly, there was no obligation for the pre-trial chamber to assess anew whether there was reasonable grounds to believe that Mr. Gbagbo committed a crime within the jurisdiction of the court, as the pre-trial chamber found that no changed circumstances existed. The appeals chamber finds no error in the approach of the pre-trial chamber, and therefore this ground of appeal is dismissed. The second ground. Under the second ground of appeal, Mr. Gbagbo submits that the pre-trial chamber erred in law by not examining the facts pertaining to each item of evidence previously used to justify his detention, and thereby declined to assess whether there were changed circumstances for the purposes of Article 63 of the statute. Mr. Gbagbo avers that the pre-trial chamber merely adverted to earlier decisions in relation to his detention rather than analyzing the current situation or the arguments of the parties. The appeals chamber notes that the principal issue in dispute under this ground of appeal relates to the manner in which a periodic review of detention ought to be carried out. The appeals chamber recalls that there is a clear difference between the standard of a decision under Article 62 of the statute and under 63 of the statute. While a review of detention pursuant to Article 62 entails a decision de novo, in which the pre-trial chamber must decide whether the conditions under Article 58(1) are met, the pre-trial chamber may modify its ruling on release or detention under Article 63 of the statute only if it is satisfied that changed circumstances so require. The appeals chamber has previously held that the chamber does not have to enter findings on the circumstances already decided upon in the ruling on detention in the absence of changed circumstances, given that the scope of the review carried out in reaching a decision under Article 63 of the statute is potentially much more limited than that to be carried out in reaching a decision under Article 62 of the statute. The appeals chamber therefore finds Mr. Gbagbo's argument that the pre-trial chamber erred in failing to perform a systematic review of each of the circumstances which had provided the basis for the detention in order to determine whether any of these had changed, distorts the manner in which reviews of detention pursuant to Article 63 of the statute should be conducted. Indeed, it is first for the chamber to determine whether changed circumstances exist to warrant the disturbing of a previous ruling on detention, rather than addressing each factor underpinning detention in a de novo manner to determine whether any of these have changed. On this basis, the appeals chamber finds that the pre-trial chamber did not err in finding no change in the relevant circumstances that would affect the grounds justifying detention under Article 58(1)(b) 1 to 3. Accordingly, this ground of appeal is dismissed. The third and sixth grounds of appeal. Mr. Gbagbo's third ground of appeal is that the pre-trial chamber erred in law by declining to assess the probative value of the final report produced by the group of experts on Côte d'Ivoire, despite Mr. Gbagbo's request. His sixth ground of appeal is that the pre-trial chamber committed an error of fact by relying on the findings of this report, that is, the final report, despite the fact that he had called the probative value of the report into question. Given the overlap in these grounds, the appeals chamber treats them together. In relation to the third ground of appeal, the appeals chamber finds that to the extent that Mr. Gbagbo argues that the pre-trial chamber should have reconsidered its previous findings that were based on the group of experts' midterm report, Mr. Gbagbo's submissions before the pre-trial chamber did not contain new evidence as he now claims on appeal. Rather, he raised before the pre-trial chamber a number of arguments generally challenging the quality and reliability of the group of experts' work. The appeals chamber finds that the majority of his arguments could have been raised in relation to previous decisions of pre-trial chamber, most notably the decision of 12 November 2012 or 12 March 2013, which relied upon the findings of the midterm report. Furthermore, the appeals chamber finds no error of law on the part of the pre-trial chamber in failing to analyze the probative value of the final report. The pre-trial chamber did in fact consider the factors which may have impacted on the reliability of the final report with reference to the applicable standard by which it assessed the evidence before it. Thus, the third ground of appeal is dismissed. Likewise, the appeals chamber finds that Mr. Gbagbo's sixth ground of appeal must also be dismissed as it merely rehearses his arguments in relation to his third ground of appeal. Fourth and fifth grounds. Under his fourth ground of appeal, Mr. Gbagbo argues that the pre-trial chamber committed an error of fact in considering that the publication of the final report did not constitute a changed circumstance. In his fifth ground of appeal, Mr. Gbagbo alleges an error of fact on the part of the pretrial chamber for refusing to consider the alleged links between the prosecutor and the group of experts, as well as an error of law in failing to clarify this issue upon Mr. Gbagbo's request. In the appeals chamber's view, the mere publication of the final report cannot support the existence of changed circumstances. Only facts contained therein could potentially result in changed circumstances that may impact on the factors justifying detention. The appeals chamber also notes that Mr. Gbagbo does not indicate which purported discrepancies between the midterm report and the final report should have been taken into account by the pretrial chamber, or how they would have impacted on the pretrial chamber's findings. Furthermore, in relation to the fifth ground of appeal, the appeals chamber finds that Mr. Gbagbo fails to provide any concrete evidence establishing collusion between the prosecutor and the group of experts, and that his arguments are speculative at best. Recalling that the appeals chamber will interfere only in the case of a clear error, it finds no such error to be established, and accordingly, the fourth and fifth grounds of appeal are dismissed. The seventh ground. Mr. Gbagbo's seventh ground of appeal is that the pretrial chamber erred in law in finding, without giving reasons, that Mr. Gbagbo could have access to funds. In his document in support of the appeal, Mr. Gbagbo argues that he only has 2 current bank accounts and that no other accounts exist, a fact which, in his view, the pretrial chamber ignored. He also argues that it is impossible for him to prove that further unfrozen accounts do not exist. He avers that the risk identified by the pretrial chamber that he still has access to other or hidden accounts is based on a mere series of hypotheses, and that it is impossible for Mr. Gbagbo to prove changed circumstances. The appeals chamber notes that Mr. Gbagbo does not explicitly allege an error of fact in relation to the pretrial chamber's appraisal of his access to funds. He argues instead that an error of law was occasioned by the pretrial chamber failure to give reasons for its finding. However, according to the jurisprudence of the appeals chamber, there is no requirement to give reasoning or engage in a de novo review of detention where no changed circumstances are established. Therefore, it follows that it will need to be established that changed circumstances existed in relation to Mr. Gbagbo's financial situation in order to support an argument that an error of law was occasioned due to lack of reasoning. On this basis, and in the absence of any further information coming to light since the decision of 13th July 2012 regarding unfrozen bank accounts, the appeals chamber dismisses Mr. Gbagbo's seventh ground of appeal. The eighth ground. Mr. Gbagbo's eighth ground of appeal is that the pretrial chamber committed an error of fact in considering that a pro-Gbagbo support network exists. The appeals chamber dismisses the eighth ground of appeal as it rehearses many of the same arguments in relation to the second ground of appeal. As the pretrial chamber's finding in relation to the existence of a pro-Gbagbo network was based on the findings in the final report and not the midterm report as erroneously suggested by Mr. Gbagbo, the appeals chamber finds that it was not unreasonable for the pretrial chamber to rely on the final report. In the absence of the identification of a clear error, and to the extent that an appellant's mere disagreement with the conclusions of the pretrial chamber are not enough to establish a clear error, the appeals chamber finds that the pretrial chamber did not err in finding that there remains a network of pro-Gbagbo supporters. The ninth ground of appeal. Mr. Gbagbo's ninth ground of appeal is that the pretrial chamber erred in law by not taking into account his health and its assessment of whether his continued detention remained necessary. On appeal, Mr. Gbagbo alleges that the pretrial chamber erred in failing to consider that the effluxion of time itself and the evolving nature of Mr. Gbagbo's illness are in and of themselves changed circumstances that have an impact on his detention. In this regard, the appeals chamber notes that the pretrial chamber did not enter into a discussion of the substance of Mr. Gbagbo's arguments, but noted that Mr. Gbagbo's arguments merely repeat previous submissions and fail to raise a new circumstance. The appeals chamber can discern no error in the pretrial chamber's treatment of these alleged circumstances. Mr. Gbagbo's reference to the reports of medical experts did not constitute changed circumstances, as these were previously assessed by the pretrial chamber. Thus, in the absence of any evidence in support of his assertion, the pretrial chamber cannot be faulted for rejecting Mr. Gbagbo's arguments as being merely repetitive. Accordingly, this ground is dismissed. The 10th ground of appeal. Mr. Gbagbo's 10th ground of appeal is that the chamber erred in law in its examination of the requirements for conditional release. Mr. Gbagbo contends that the pretrial chamber erred in not reasoning why guarantees would not minimize the risks and justify conditional release. In addition, he avers that it was incumbent upon the pretrial chamber to explain, point by point, why the numerous security measures proposed by a potential host state would not mitigate the risks. The appeals chamber finds that Mr. Gbagbo's arguments concerning the lack of reasoning of the pretrial chamber in rejecting the proposal from a potential host state are untenable, as they relate to submissions he made in relation to previous decisions of the pretrial chamber. The appeals chamber notes that for the period of detention under review, the pretrial chamber did not consider any new proposal from a potential host state, as no fresh proposal was presented. In the circumstances, the appeals chamber considers Mr. Gbagbo's arguments that attempt to relitigate issues on appeal that were the subject of previous decisions of the pretrial chamber and which do not arise in the impugned decisions to be appropriate, and they are therefore rejected. For these reasons, the appeal chamber considers it appropriate to dismiss all grounds of appeal and to confirm the impugned decision. As I mentioned at the start of this summary, Judge Eki Kurula appends a separate opinion, while Judge Anita Ochaska appends a dissenting opinion to this judgment. In Judge Kurula's view, the absence of sufficient reasoning in the pre-trial chamber's decision of 13th July 2012 makes an assessment of changed circumstances in the current review of detention problematic. In his view, this is reflected in the pre-trial chamber's assessment of the grounds for detention under Article 58(1)(b)(2) and 3 of the statute. Given that the grounds for detention under Article 58(1)(b) of the statute are in the alternative, he would have found that Mr. Gbagbo's continued detention is justified under Article 58(1)(b)(1) alone, and not pursuant to Article 58(1)(b)(2) and 3 of the statute. In Judge Uchaska's view, the pre-trial chamber should have considered, when issuing the adjournment decision, the reasonableness of the length of Mr. Gbagbo's detention and any prolongations thereof caused by the adjournment. Judge Chaska is of the opinion that the adjournment decision constituted changed circumstances that would have required the pretrial chamber to consider anew the basis of Mr. Gbagbo's detention. In her opinion, changed circumstances exist because the adjournment decision casts doubt about the evidentiary basis underpinning the charges as a whole, and these doubts necessarily extended to the lower evidentiary threshold laid down in Article 58(1)(a) of the statute. In finding that changed circumstances that existed, Judge Uchaska would have granted the first and second grounds of appeal, reversing the impugned decision and remanding the matter to the pretrial chamber for fresh consideration involving a de novo review of Article 58(1)(a) and (b) of the statute. This concludes the summary of the judgment. Thank you very much.
All right, veuillez vous lever.